We have laws like the Land Act of 2012 that acknowledges the gender principles when you're valuing land in matters compensation. We have the Land Registration Act of 2012 that talks about women being entitled to be owners, even if their names are not on the titles. The law perceives them as beneficiaries because the name on the title is viewed as a trustee. We have the Community Land Act of 2016, which is very progressive because Kenya is 70% communally owned. Under communally owned lands, traditional governance systems do not really recognize the role of women. So women have generationally been excluded from land governance. So this Community Land Act of 2016 is very progressive in a sense that each adult in a community has a vote. It's not a family head, because before then, the eldest male in a family would hold in trust. But Community Land Act of 2016 provides that every family member has one vote. So the women who've been married into the home, the women who've been born in the home, they have a vote. It further provides that women should be part of the small community land management committees, something that never used to happen. Okay. Women should be part of the natural resource governance committees. Okay. So I'd say in terms of legislative framework, we have very beautiful pieces of legislation. I wish they could have been enforced as envisaged.
A will seems like a very strong protection mechanism for women. What are the challenges that you've seen associated with putting together a will in a marriage that can protect a woman after the husband passes, especially if there could be family members that might want to acquire the land of the late spouse? Is a will a good idea? Is it practical? Is it possible in an African context?
It is practical. It is important, but it's not absolute. It can actually be revoked, and some of the property be reallocated to family members. Maybe, let's say, the children, they call it legitimate children. So it is practical, and it happens. But in the Kenyan context, you get that people feel when you write a will, you're inviting death. So you get that very many spouses die intestate. So when they die intestate, then that aspect of family sitting down and deciding who would be the administrator comes in. Even for years, that issue of bride price normally comes up again and again and again. So there's that aspect of linking how if a woman is a wife first, before we even start talking about the woman having the right to possess the matrimonial property that her husband has left her with. And remember, there is the issue of inheritance, and there's the issue of possessing matrimonial property that both the husband and the wife have equal share to. So the claiming of that right is what is usually compromised, because not so many women are willing to go the whole hog because of the complexities and the fear of the unknown.
What can government do, in your view, that could facilitate some of those things? Would pro bono lawyers be of help? Or what can be done, in your view, on the government level?
Of course, the government, what they can do, number one, is to simplify the discussion, simplify the discourse, simplify the processes. The succession process is very expensive, it's lengthy, it's adversarial. The backlog in most of these courts discourage widows from going through that process. The government can also develop multi-stakeholder forums at local level, which then would simplify the discussion and make the widows in most areas own the discussion. There's the issue of resourcing of the women land rights agenda. They help women access and own land. A land registrar should not register a community that has not adhered to the law. That would empower women to be able to make decisions around land, around natural resources. And lastly, the issue of supporting women to access credit in order to improve their livelihoods.